Do many of you remember the BBC TV show called 7 Up?
Yes.
Where there was some of the younger people, like Jane and I remember, I mentioned this to him many months ago, and he had no idea about what this show was, but some of the older generation still recall this TV program. They basically took 10 people in England, and they said, and they came from all walks of life, and they visited them, and they interviewed them every 7 years throughout their life. And I believe the program is still running, and the people would be roughly 63 or 70 at this stage. In a similar fashion, following on from Mark's discussion about guardianships and the powers of attorney, your will is a document which you should really pause and reflect and have a look at that 7-year cycle in your life. If you think about it, when you're 14, there's a change, you become an adolescent. 21 was the historical day you became an adult. 28 is probably time to think about marriage. 35, children. 42, help me, 42, when your children are starting to get a bit older. 49, they're starting, they have different needs. What's move out, and I need help, I haven't got my calculator. 56, bingo, 56, the children are moving out. 63, you need to think about retirement. 70, your will becomes quite important then, doesn't it? So you think every 7 years, I'm not suggesting you change your will, I'm just suggesting you need to think about, is it time, is my will adequate for the conditions I currently find myself in? Communication in your wills is paramount. As Mark was saying, talk to people. In respect to attorneys, powers of attorney, I would also suggest with your wills, communication, talking to people who have an expectation that they may be entitled to receive something. Do it now before it's too late, because really the last people you want to receive benefit out of your estate are solicitors and accountants. And too often we've charged and spent a lot of time trying to sort out issues which should really have been sorted out before somebody died. When does a will become ineffective? Two that spring to mind for me. If you write a new will, your previous will is no longer an existing will. If you get married, all your previous wills don't count. If you get divorced, what's the rough feel? What do people think? If you get married, you've got to make a new will. Your old one doesn't count at all. What about if you get divorced? You think your will still counts? It does. So getting divorced does not nullify an existing will. So if you forget to change your will many years later, your
new wife won't be happy.
Your new wife? Well, no, if you got married again, your old will would have been changed. So when you consider your will, you need also to consider what are the assets you own. I've been talking to somebody recently, and they said, well, we want the business to go to the son, and we want the assets to go, these other assets to go to these other daughters. And I said, but the company owns the business, and the same company owns all these other assets. You don't own them. You can't give them because you don't own them. It's the company which owns them. And that came as a shock to them. So you need to work closely with your advisors so that you understand the structure that you've got personally in place to determine whether you're in fact able to give your assets through your will to whom you choose. Think also about tenants in common versus joint tenants. Joint tenants, whatever you hold jointly, passes on to the person you're holding that asset with. An example there is bank accounts. So if you hold a bank account jointly with your spouse, upon your death, the asset does not go through your will. It passes automatically through to the survivor. If you own real estate as joint tenants, similarly, that real estate does not pass through to your will. It goes through to the person you're holding that property jointly with, to the survivor. If you've got tenants in common, then the asset passes through your will and is allocated to your beneficiaries as per your will. What happens if you die without a will? I can share an example with you. This family couple, they lived up the north coast of New South Wales, and they had one son. They had a farm, and they decided, well, we all got really well, we're trying to do some succession planning here, let's pass the farm on to our son, which they did. And they all got on really well. And then the son met a young lady, and they got married, and they all got on really well. Sadly, the son died, and he died without having a will. So the natural course is that, okay, we don't have a will, but he's married to this young lady. We'll give the farm, which the parents held originally, to his wife. So now the farm rests with the wife of the son. They had no children, and the parents and the daughter-in-law got on really well, and everything went fine. Sadly, she died, and you would have thought they would have learned, but like her husband, she had no will. So now you've got the case of the parents who held the property originally, transferred it to the son who died, transferred it to the daughter, to his wife, the daughter-in-law, the parents. She died without a will. Where does the family farm go to? And there were no children. Well, it goes to her parents. Now, the farm was in northern New South Wales, and her parents lived in South Australia. And guess what? The parents did not get on. And the farm ended up with the parents down in South Australia. So the original owners of the property, sadly, had no farm. So it's, there are certain, you probably need to talk to Mark about the precise order, but if you don't have a will, it's called dying intestate, then the courts have a certain order of steps to take until ultimately, if there's nobody left, it is your government and my government who will receive the benefit of your estate. Just moving on now to planning with your will. A lot of people, when they have an asset which they are going to pass through their will to the next generation, would like their asset to stay with their bloodline. So think of, for example, a young couple, married, have children, husband dies. his wife, who's only in her, say, early 30s, has 3 children. The asset passes through to her. Well, she ends up, she's still very young, so she marries somebody else. And the person she marries has 2 children. So now we have a mixed marriage. So the assets that the husband and she had developed together now pass through to her. And let's say she dies, her assets then typically pass through to her spouse. And he now has children, 3 from the first marriage, of which he's not the father of, and 2 from his first marriage, which he is the father of. He would, I guess, have a tendency to favour the 2 children from, which are through his bloodline, as opposed to the three children he, if you like, married into. So, by having a trust in your will, you can have some control as to where your assets can pass through to, so that your assets pass down through your bloodline, as opposed to potentially leaving your family group and passing through to a married family bloodline. A trust, what is a trust? So a trust is an entity governed by a legal document called a trust deed. It originated back in the time of King Arthur and Sir Lancelot. As the English nobles went off to war down in the Holy Land, women in England were not allowed to own real estate. And so the knights would say to their knights at home, I am going to give you my real estate for you to hold on trust for my wife, so that if I do not return, you're to manage this land on behalf of my wife. But if I do come back, then it's my property. So that's how the whole concept of trust law started. It's an English concept. It only operates in England and Australia, possibly New Zealand. Doesn't exist in America. It doesn't exist overseas in many countries at all. But it allows us to create a legal entity for up to 80 years, whereby an asset can be passed through to this trust. And when the trust is eventually wound up, the asset falls through into the hands of the people intended. If you create just a simple couple of lines in your will to say that you want these assets to pass through to through a trust, through to my children, held by my spouse in trust, then we also get the benefit not just of having your bloodline being able to control where your assets are being passed through to. There are also some tax advantages. And these tax advantages clearly operate very well where you have lots of money. So for example, if you have term life insurance worth $2 million, if you die, the $2 million might be passed through to your wife. You invest that money, she earns, say, $100,000 of interest a year. She's taxed on the $100,000. If you decide, no, that it should be, I want my children to each have the $2 million with my wife, so that the whole asset, the $2 million, is shared equally between all of my family. The tax on children under the age of 18 is 66%. So if the children had an asset of about $500,000 and earned $25,000 a year interest on that asset, they'd be paying tax of around $16,000. But by having the asset allocated through your will, through a testamentary trust, the children are taxed not as minors, so they're not taxed at the penalised 66% rate. They're taxed as if they were normal adults. So in other words, if you've got the $2 million allocated through to a trust through your will, then all four, so if you have 3 children, your wife and your 3 children can share in adult tax rates. So testamentary trust in your will, simple to add in, gives you great control as to who is going to receive the assets over the long term, and secondly, gives you fantastic tax benefits. I'm being given the nod here to wind up. So thank you for your attention.